Oh. All right, there we go. Julie just disappeared. The announcement has been made. Recording is in progress, so I believe we are live. Welcome to all who are attending. This program is one of the MEAB lunchtime webinars. In particular, today it's going to be collections and statutory changes in Massachusetts and in New Hampshire. I will start out, as I always do, with a sincere thank you to the folks that are joining us, because if people did not take some time to share these seminars with us, then we would sort of be wasting our time. So we do appreciate your presence at these things. Presenting today first is going to be Dean Lennon. Dean is one of our partners here at MEAB, one of the folks who is focused in the practice of condominium law, one of the most knowledgeable folks doing this at this time. And Dean practices in both Massachusetts and New Hampshire, as do I. So today we've sort of split up the two states for purposes of just carrying the workload. But Dean is going to start out and speak to Massachusetts.
Well, thank you very much, Gary. I'm just going to give it 10 more seconds as people roll in. We're up to 67. I'd love to get to 98, but we'll just give it one more second.
Okay, yeah, there are more. I should have paused. There are more people on the list, so sometimes it does take time to get all the connections.
I am coming to you from our world headquarters here in Braintree, Massachusetts. Gary is at our, what we call MEAB North in Merrimack, New Hampshire. So we have all our bases covered here. And as the participant totals slow down, I am going to get going. So the start of this seminar is going to be on the recent changes in Massachusetts and New Hampshire, with me taking the lead here for Massachusetts. So let's dive right in to brand new section 24 of the condo statute. And this pertains to board meetings. There's three sections. We're going to start talking about 24A pertaining to board meetings. And what this says here, I'm not going to read it, but it says, notwithstanding what's in your condo docs, a board can have a regularly scheduled or special board meeting by telephone, video conference, or other electronic process. So that could be an app, it could be something we don't even know about yet in terms of technology, but it leaves open various possibilities for how you as a board can conduct your meetings. So let's just look at the language a little bit closer. All participants should be able to simultaneously communicate with each other during the meeting. So that's easy enough by phone, by Zoom, by whatever app you might choose. And presence by that electronic means would satisfy quorum requirements. So if Gary and I are on a 3-person board for our condo, the 2 of us are here, that's more than half. So we've now satisfied the quorum for our small condo, and we can get on with the business at hand. And of course, the governing body might vote at this electronic meeting and approve the meeting minutes. So basically, all the things that boards started doing as a result of COVID in mid 2020 that have persisted to this day are now blessed. You know, at the time we said, well, what are you going to do? You can't meet in person. You got to do something. So let's meet remotely. And then, you know, by the end of 2021, now there's no more mandatory closures. Schools are opening up, businesses are opening up. But still, you know, boards got used to this sort of thing. It's incredibly convenient. So it sort of persisted as a practice. And our very own Matt Gaines, who's part of the Massachusetts Legislative Action Committee of CAI, was key in getting this passed. So now you don't have to worry, is this legal? If you're in Massachusetts, it is in fact legal. So we were just talking about Section 24A. Section 24B pertains to owner meetings, not board meetings, but owner meetings. And I'm not going to read this to you. You will get the slides by automatic email, probably by tomorrow, but maybe today. But let's talk about Section 24B on owner meetings. So virtual owner meetings by telephone or video conference or other electronic communication process is a valid meeting, and that can be determined by the board. The board can say, no, we don't want to do this, or they can say, we want to do this. You can have a hybrid meeting where you have people in person, maybe at the library or a common space at your condo, and then have people available to join remotely as well, or it can be fully remote. It's all up to the board. The board must notify owners of the meeting and provide access on how to participate. Of course, that's nothing different than you're normally doing. You've got to give usually 21 days notice of an annual meeting, usually 7 days of a special meeting. The only difference here is you're giving a Zoom link or a meeting ID, something like that. Just like board meetings, remote participation counts for quorum purposes. So if your quorum is 20 unit owners and you have 20 unit owners on that screen, well, you've got your quorum. And the governing body, that is the board, must take reasonable measures to ensure that owners can fully participate, including reading or hearing the proceedings and posing questions or comments. So again, that's easy enough with Zoom. You all can see and hear me right now. You can see my screen. If we wanted to, we could let people appear and chime in. So, using something like Zoom, Microsoft Teams, these things are very easy to satisfy. And we're up to 89 people, so that's great. And I should have mentioned this at the top, but if you have questions, put them in the chat. Gary will read it while I'm talking. I'll read it while he's talking. And if we can answer your question in real time, we will. Otherwise, we'll do it at the end. And Gary, if you have something to say about what I'm saying, please chime in anytime.
Sure thing. And yeah, so far we're clear on the chats and the Q&A.
For some reason, I don't see the Q&A. So, oh, there it is. Is that it?
Yep.
Oh, I see it now. Yeah, use the Q&A, please, not the chat. I apologize. Now I've got the Q&A open now. So, go ahead, Gary.
There is a question, Dean, that literally just popped up. You may want to address this now because I think it relates to what you were just covering. Can you still hear me?
Yes.
All right, I've lost my monitor picture completely.
Well, I do see the question as you get up. It says, with a unit owner meeting, must all participants be able to see and hear each other? Yes, absolutely they must. For example, people come in. Oh, I see what you're saying. So I think if the owners online can't see the owners in attendance, I think that's fine, as long as they can hear each other. I mean, and see them, maybe see their presence. I don't think they have to see their face of every single person. But as long as the people online can hear the people in person and vice versa, I think you have no issues. So we talked about board meetings, we talked about owner meetings, and now we're talking about voting under new section C of new section 24. So the governing body, again, the board, must allow or may allow owners to vote on any matter by mail-in ballot or electronic votes. However, a quorum of unit owners shall be present for the vote, and I highlighted shall be present. And let's get into the language here. So the board may not have to, but may allow owners to vote on any matter by mail-in ballot or electronic ballot if you have the quorum present. But what does that mean, shall be present? This was kind of some weird language that we didn't expect to be in there. So if you're having a Zoom meeting, presence is easy. If you're on the screen, you're present just the same as you are if we're in the same room together. But if you're doing a vote by mail, there's no presence. So on one hand, the legislature is telling you, go ahead and do a mail-in vote, and that's kosher, but shall be present. So we'll get back to that. The original draft of the amendment had no such shall be present language. It simply wasn't there. So I can think of two ways of interpreting this. One is, even though you can mail in ballots, there has to be a physical aspect. So the physical aspect could be a couple of board members in a unit physically present. and they're getting proxy ballots. So the ballot is not only a vote, but it's a proxy for physical presence at the meeting. So in that sense, even though you might have, say, 2 or 3 board members in a meeting physically, um, everyone who's participating online, or excuse me, participating through their mail-in ballot is kind of there for presence purposes. I prefer interpretation 2, which is the act of mailing the ballot is your presence. If you have a quorum that requires 20 owners or 20% of the beneficial interest, and you get 20 votes or 20% of the beneficial interest, to me, that's your quorum. Because otherwise, you just can't square this language. You can vote by mail, but you're present for the meeting. It simply doesn't make sense. And I don't know why the legislature changed it. They did, we're stuck with it. So that's my view of it. Just looking at a couple questions, is a quorum necessary to hold board or other meetings? Absolutely, yes. Whatever your quorum is for a board or owner meeting, it's still the same. It's just the difference is they can participate remotely. So as I was saying, if we have a board of 3 and Gary and I are both here at the meeting, we have more than 50% of the members. Therefore, we have a valid meeting. We've done mail-in ballots, but they're not opened unless a quorum is present. Is that okay? Well, I think you need to take the people in person plus the ballots, as long as they're proxy ballots, and that combined is the quorum. So that's fine, as long as you're, the mail-in ballots, as long as they're sort of styled as a proxy ballot, or even if not, honestly, I think with this new language, if someone's sending in a ballot, to me, that is presence at a meeting. So I think you just want to add up the both. Would an appropriate means or method to store to store election results, what would be an appropriate means to store electronic results? I mean, I think you can be as creative as possible. Certain, third-party software might allow you to just download the results. You might be able to just save the Zoom meeting. Our office manager put the Zoom meeting together. She's going to get an email with the video of this. So, you just store it on a computer and Bob's your uncle, as they say. I think you could also just have the secretary record the minutes and say, we took a vote, we counted the hands in favor, and that was 24. We counted the hands against, and that was 10, and the measure passed. I don't think anything fancy has to happen. I think you can be creative, and as long as you're accurate, that's the bottom line.
If it's a ballot issue, I always like to advise clients to keep track of those ballots. In other words, if the election results are challenged, or if it's an amendment situation and someone says that the amendment is challenged, whether or not it was validly passed. So if you're getting ballots from owners, whether they're on paper or electronic, I would save them. If you have done paper ballots, but you're trying to do like electronic record keeping, and your association does not want to have boxes of papers, then I would just go ahead and scan those ballots in as like a PDF file and keep it with the rest of your electronic records.
One more question before I move on to this new slide. Given that a cast ballot constitutes presence towards the quorum, would it be proper to say that if a ballot is contested as to its validity, and if the ballot is determined to be invalid, would that not count towards the quorum? And yeah, I would agree. If you found out that someone sent in a fraudulent ballot, I pulled it out of my neighbor's mailbox, filled it out for my neighbor, and sent that in. Yeah, if you prove that, that would not count. Hopefully that does not happen. In New Hampshire, any proxy has to have a control number on it. We don't have that requirement here in Massachusetts. You could put in some measures to sort of try to mitigate against fraud, but I think it's impossible. But I also think it's going to happen in an incredibly small number of cases. Because frankly, if you have to cheat for condo elections, you've got bigger problems, in my respectful opinion. So more on Section 24C. the board may promulgate and amend policies related to electronic meetings and voting. So the board can basically develop policies with perhaps approved software to use, how meetings are run, the way owners participate. You have that ability as board members to sort of create the rules of the road, if you will, when it comes to electronic voting. You don't have to do that, but I would suggest that it's a good idea, for uniformity's sake. Figure out how you want owners to participate. Maybe you're muting everybody and calling on people. Maybe you're using the Q&A function. There's no single right answer. It's what you as a board think is right, what works for your community, perhaps reacting to what has happened in the past. I mean, some meetings, and I know Gary's been part of them as well, if you just leave everyone off mute, it is going to be a bleep show, that is unwieldy. So, perhaps the board does their thing, then the owners get a chance to, get a minute, get 2 minutes, whatever the case may be. Just develop a policy and stick to it. Moving on. So not only did you have the electronic voting and meeting change, you now have some changes to the statute in terms of electric vehicle, EV charging, and solar panels. So as we saw in Boston and Cambridge in maybe 2021, 2022, something like that, the whole state now has what's commonly known as a right to charge law. And this is a brand new section 10A of the condo statute 183A. So just like Boston and Cambridge, if you're familiar at all with those local laws, condos are prohibited from banning the installation of electrical vehicle charging stations in an owner's exclusive use area. So you're prohibited from banning, which means you can't have an outright ban. You can't say our condo simply does not allow electric vehicle charging stations. That is no longer an option. And it's further not an option for condos to unreasonably restrict installation. If an owner has, say, a deeded parking spot, a driveway, and they can install the EVCS without infringing on anyone else's rights, you now have to allow that. And if you're going to have any takeaways, note this last bullet point that when you get an application from an owner, you have 60 days to approve or deny. And if you fail, it's deemed an approval. So don't sit back and do nothing. If there's a basis to say no, do that within the 60 days. Before I move on, I see a new question about back on the meetings. If we invite only owners to virtual owner meetings, do we have to vet the logins to be sure they're owners? Yeah, I mean, that is hard. Presumably, you've sent out the invite only to email addresses you know. So you should be able to figure out if it's legitimate or not, but I suppose that email could be forwarded and someone else joins on. I guess I just don't lose much sleep over things like that, because why would someone else, attend the meeting? And if there's any doubt that, it says Dean Lennon under my name, if you don't think it's really me, I suppose you could just exclude me. But unless that person's causing a problem, or trying to vote, of course, I wouldn't be too worried. So let's go on to more about electric vehicle charging stations.
Dean,
Under the new section E. Oh, sorry, Gary, go ahead.
Just real quick on that last question. I think some of the apps help with that. I'm not an expert with these apps, but I think some of them do allow the association to provide the service with the list of folks who are logging in, and they somewhat vet that access. But I'm sure it varies, app by app. You had one more question pop up, Dean.
Sure.
Which is, what if the parking spots are, this is now on the charging, what if the parking spots are in a shared garage or parking lot? Can the request be denied?
So this right to charge law pertains only to exclusive use area or limited common area, you might refer to it as. So if you're talking about a garage or a parking lot where it's a first come, first served basis, there would be no automatic right for that owner to install an EVCS anywhere. But if the owner had space number 10, there was a reference to space number 10 in the deed, and only unit A could use space 10, you can't unreasonably interfere with their ability to install a charging station for that spot. So I guess the answer to this question specifically is it depends whether that owner has deeded rights to the spot in question. So not only are there some obligations for boards under this new section of the statute, owners have some obligations too. They need to disclose the EVCS to prospective buyers. They have to let buyers know whether the equipment is removable or not, and what all of their obligations are with respect to the EVCS, including the costs of maintaining and repairing the equipment, as well as the cost of electricity. So you don't need to worry about this as a board member, but as a unit owner, if you happen to have installed one of these, you do have some obligations now under the statute when you go to sell your unit. So let's just do some key takeaways here. A board cannot create an outright ban on EVCS installations by owners in their exclusive use areas. If an owner can install the EVCS without infringing on the rights of others, and I'm talking about, we see this all the time, an extension cord across the sidewalk. Never going to happen. You cannot do that. It's a tripping hazard. It's going to interfere with people walking around. Can't do that. But if they can, put a wire underground at their own expense from the spot to their unit or to a breaker somewhere, you're probably going to have to allow them to do that. And again, if you remember what I said, you're prohibited from making unreasonable restrictions. So the inverse of that are reasonable restrictions are okay. So what are reasonable restrictions? Owner pays for everything. The board is not shelling out money for an owner to have an EVCS. The owner must also pay for the electricity. The owner can be made to remove the EVCS if maybe you're doing a paving project and this is just going to be in the way. You can make the owner temporarily remove it, do the paving project, then put it back, all at the owner's expense. You can require them to use licensed and insured contractors and require a written agreement. Often when we're doing things like generators next to units or maybe a mini split, we're doing an easement agreement. So we clarify the respective rights and responsibilities of the owner and the board with regard to what an owner has installed. And that sort of thing is reasonable and okay. And the final note here is that owners just can't go do this. They can't say, hey, right to charge law, I'm installing one of these next week. No, you still have to ask permission. You still have to go through the process that the board puts in place. Just looking at some questions here. Can the association charge the owner for the cost? Yeah, the owner's going to pay for the entire installation. So don't worry about that. What if electricity is included in the condo fee? That is so rare, but I guess you wouldn't be asking if it weren't the case for your condo. I think you would have to figure out, get a baseline. For the last year, electricity is $200 per month. All of a sudden with the EVCS, it's $220. So that owner is going to pay that new $20 delta. Might not be perfect, but it's better than nothing. When an owner has deeded rights to the spot, but not to any area around the spot, what are the board's options? Well, yeah, that's normally going to be the case. If we're talking about a driveway or a spot, it's really the rights are only for that, where the car goes, nothing around it. But nevertheless, no unreasonable restrictions. If it can be done, the board is almost certainly going to have to allow it to be installed. Does the EVCS require an easement? It doesn't require one, but you can do one. So we also had some changes to section 10B6 of the condo statute, and this is going to relate both to solar panels and to EVCS. So what you're seeing in front of you right now is the existing language. This has not changed. It talks about boards requiring energy-saving devices to be installed, and you'll note that it says that energy saving devices are not an improvement. Why does that matter? If we're talking about an improvement, let's just say putting in a tennis court or a pool where right now there's only grass, that requires a vote of 75% or more of owners to use common funds for that project. So there was always a question, well, are solar panels and EVCS, are those an improvement, or are they just require a majority vote at a meeting under 10B6? So these amendments clarified what the deal is for both. For solar, it is an improvement. So if you're going to do a solar project for the entire condo, that will give energy to all owners, that's going to require an improvement vote, 75% or more of owners, and then you can pay with common funds. Or even if an owner wants to install on the roof, you're still going to need the improvement vote. But EVCS is sort of exempt from the improvement vote, and you only need, let's say the board wants to install a bank of EVCS at, in the visitor spots or just in open spots in a general common area parking spaces. You'll need a majority vote at a meeting to approve that. And so far easier than the improvement vote. Let's just take a look at the questions here. What does the EVCS require? No, I got that one, sorry. Can you require a separate meter for the EVCS? I don't think you can, but you can figure out a way to charge just the owner for the fees. I mean, I guess that's on the borderline. Gary, what do you think about that? Could you require a separate meter? I mean, I guess if it's feasible, you could.
Yeah, I think it would depend on whether or not there's a way for the association to otherwise get that information. In other words, the law clearly states that the owner who's doing the charging needs to be paying for that electricity. So I guess it boils down to, is there a way for them to be able to discern what that bill is without a separate meter? If so, then they probably have to do that. But I think if a separate meter is the only way to do it, then I would say the association could probably get away with requiring that meter.
Yeah, there's no like any new statute, there's no guidance around these sorts of things right now. So we have to sort of go with experience, go with our guts. As I think about it, I do agree with Gary. Is it unreasonable to require a separate meter? Probably not. I mean, it takes a lot of energy to charge a car because I have an electric vehicle and I can see it through the app. I mean, when you're charging that car, it is a tremendous amount of electricity. So yeah, I think as long as it's not unreasonable in some way, maybe for whatever reason, if the costs were astronomical and you have another way of figuring out the increased electricity charges for the EVCS, you're probably okay. Next question, is that MA or NH? I am only referring to Massachusetts with this entire section from 12 to currently only about Massachusetts. Our condo has duplexes and single family homes. If an owner wants to install solar, do 75% of all owners have to approve. If an owner is installing the solar on his roof, which is part of the unit, you're going to have to let that go. That wouldn't be an improvement because the owner is the one in charge of maintaining the roof. It's really when someone's installing solar on a common roof, that's when you're going to need that vote. Can you restrict EV charging to not allow in garages? You couldn't. I guess the answer is it depends. Does the owner have an outdoor and indoor spot? If so, I suppose it would not be unreasonable to require that owner to do the installation outside. But there might be reasons that you would have to allow it in the garage. A lot of these things are incredibly fact specific. So, my
Yeah,
guidance to those in attendance would be, asking yourself, is what I'm asking the owner to do reasonable or unreasonable?
yeah, I'll share this without naming names. I do have a case right now that involves a EV charger in a parking garage, an underground garage at that. And there's actually an engineer's report in existence that says this parking garage wasn't built for this. It doesn't have the ventilation for this. It can't handle the weight if everybody does this. And if one of these fires happens in this underground garage, it's going to be an absolute disaster. So where the board cannot make unreasonable restrictions, like you say, on a fact specific basis, I am now of the opinion that there might be times when a board could make some restrictions that are based on safety, and based on things like a professional engineer's opinion where, they might be allowed to prevent this in a situation where it would just be too risky.
Yeah, to me, nothing could be more reasonable than saying no based on safety. Especially when that opinion is coming from an expert. Couldn't be more reasonable, in my view. So that includes sort of section 1 of 4 here, talking about Massachusetts statutory changes. So with that, I'm going to hand it off to Gary for changes in New Hampshire, the New Hampshire condo statute. Gary is also a partner with the firm. He's been at this over 20 years. He is an illustrious member of CAI New England's Hall of Fame. And there is literally no one that knows more about condo law in New Hampshire than Gary. So with that, Gary, try living up to those expectations.
Well, I don't even know if I can live up to that introduction, but thank you, Dean. Again, thanks everyone for attending. Going to talk about the recent changes in New Hampshire law. I will just quickly address it. Occurred to me that folks who are attending and either who have interest in both places, or even if you just have an interest in New Hampshire, having seen Dean's presentation, you might say, well, I have these questions about New Hampshire. What about electronic meetings in New Hampshire? What about electric vehicles in New Hampshire? So just extremely briefly, I will say this. In New Hampshire, the law says that your association can have electronic type meetings based on what is in your own bylaws. In other words, the statute opens the door, but it does nothing else. And so what associations need to do is an appropriate amendment to their bylaws. And then you can have electronic meetings in New Hampshire. As far as the electronic vehicles, unlike Massachusetts, New Hampshire does not at this time have a right to charge law. So the landscape is somewhat different in New Hampshire because the legislature hasn't been as forceful yet about making sure that you're allowing electric vehicles. With that, I guess next slide, please, Dean.
Sure. And just before we move on, there was a question about the 50% owner vote for EVCS. So that, just to clarify, this is a very good question. The 50% owner vote, or the majority vote, so it's not even 50%. It's you have a meeting with a quorum and you need a majority vote. That's only if the condo wants to install EVCS on general common area at using common funds. If an owner is installing one of these, they will 100% pay for all costs. So no owner vote is needed. The owner vote is because you're expending common funds. So if an owner is doing this, don't unreasonably interfere, but the owner pays for it. So moving back to New Hampshire, here we are.
Okay, so these are the most recent bills that have come out in New Hampshire. And spoiler alert, I'm already going to be able to tell you what the fate of these bills is in the slides that are coming up, but these are the most recent that were proposed. HB 383 talked about adoption of rules and amending governing documents. 537 talked about electric rates for residential condominium wells and septic systems. That's also the case with 539 and with 680. And then there was HB 462 that would create a private cause of action for unwarranted video imaging of residential property. This, of course, is the currently trendy debate about things like Ring doorbells and so on. Next slide, please. I think we might have skipped one.
Oh, I apologize. Right here? Yes.
Yep. Okay, so 383. This would add explicit language in 356B, which is the New Hampshire Condominium Act, that would state that the rules and regulations become a quote-unquote integral part of the condominium documents. Not even sure why that needs to be in the statute. I don't think anybody would try to tell you otherwise. The rules and regs don't necessarily have the same force as, say, the declaration or the bylaws, but they are certainly an integral part. I wouldn't have considered them anything other than that. There was also some language that after the sale of the units from the developer, the declaration could only be changed by at least a 51% vote of the entire community. Again, not clear why this needed to be a statutory issue, because A, there's already a provision in the statute that talks about amendment standards, and B, I think every set of condominium documents I've ever seen also has their own amendment provision in there, and condominiums are supposed to be self-governing anyway. So I think the amendment standards should be, fine and accepted as they're stated in the governing documents of each individual association. The last provision here was that the bylaws could be changed by a simple majority vote of those present at a meeting. That one to me was really sort of downright dangerous because, we all know that a lot of associations have trouble making a quorum for a meeting, and sometimes it barely happens. And if you barely make quorum at your meeting, and maybe quorum was 30% of your association or thereabouts, give or take, if you barely make quorum and then a majority vote of those present passes, you could only be talking about maybe 16 or so % of the association. And to be able to, on that small of a minority, change the bylaws of a community, which for mass people who don't know New Hampshire terminology, the bylaws in New Hampshire are sort of the equivalent of the Declaration of Trust that we would typically see in Mass. That's a small percentage of the community making a really important change. In any event, we don't need to worry about any of this language because this was ultimately deemed inexpedient to legislate in this year's session, so this bill has gone away.
And by the way, inexpedient to legislate is code for the bill was killed. It's probably the nicest possible way of saying the bill was killed. And if I could just give my 2 cents, this was the second worst bill I've ever seen in 15 or 16 years. The only worst one was a bill that in part sought to make board members potentially criminally liable for egregious mistakes. And Gary and I, among others, were successful in killing that bill as well. But you couldn't possibly top how bad that proposal was.
Yes, I remember those. Remember those hearings? There were New Hampshire board members lined up literally out the door,
literally
waiting to take their opportunity to tell the legislature that if you pass this law, I'm quitting my board and I'm never gonna get back on a board again. Okay, 537, 539, and 680 all pertain to residential electric rates. They were ultimately consolidated into one bill. And what the sponsor of this bill was looking for was for condominiums that were used solely for residential purposes to be charged only the residential electric rates for wells and septic systems. I had never had a client approach me with this issue before, so I didn't know the extent of the problem, but it turns out that the commercial rate is about 3 times the residential rate. And so it can have quite an effect on an association's expenses. And if an association is strictly residential, you know, just from a sort of practical standpoint, I could understand why folks would say, why in the world are we paying a commercial electric rate at our residential condo? So I think it would have been nice if this had passed. I think it would have been fair. That said, this was another one deemed inexpedient to legislate in the 2025 session. All right, 462. Creating a private cause of action for unwarranted video imaging of residential property. So this would have allowed people to bring a suit. It would have created a claim. If on adjoining property, someone was using a video device to capture recreational activities in a backyard without written consent and with an intent to harass, annoy, alarm, or threaten. I think the elements of this claim were somewhat interesting. First off, I think there was a door that was potentially going to be thrown open pretty wide here because you know, the arguments lately that people are having about surveillance cameras and Ring devices and things of that nature, it's very common. And in particular, the second part of this claim, that the intent was to harass, annoy, alarm, or threaten. Not really sure how anybody was going to prove that, since most people would say, I put up this camera for my own safety and security, and so that I can see what's going on around my own property. So I think the claim would have been problematic in a couple ways, but in any event, this was another that was deemed inexpedient to legislate. So for the time being anyway, this bill is gone. So now I'm going to turn to the most recent law that has been passed. So these were complete as of the last session. HB 1129 pertains to proxy voting in New Hampshire, and HB 1172 was an interesting bill that included some language, inserted some language, I should say, about what is not a board meeting. And okay, this I included just because I think this slide is funny. I randomly found these pictures of those folks, and I just liked the reaction. Thought people might get a chuckle. 1129 proxy voting. It allows owners to cast any vote by directed or undirected proxy. That is the owner's choice to make. A directed proxy means that the owner makes their selection and then provides the proxy to someone who will literally just attend the meeting in their place as sort of a delivery device. An undirected proxy is where the owner gives the proxy to someone who's going to attend the meeting and they have not made their selection. Instead, they are allowing that person who attends the meeting to make the selection on their behalf. So essentially, with an undirected proxy, you're giving it to someone who isn't just delivering your vote. They are going to cast your vote instead. And I guess with an undirected proxy, that means you must trust the judgment, or you should trust the judgment of the person that you're providing that proxy to. There is a limitation for small condos. If the association is less than 20 units, the statute prohibits a majority of the votes from being cast by undirected proxies. For condos of more than 20 units, the proxies cast by one person cannot exceed 10% of the total votes cast, or able to be cast for the association. Next slide, please. All right, 1172, what is not a board meeting? This is actually a bit of helpful legislation. I think it's kind of nice that this passed. It allows New Hampshire boards some flexibility. This allows board members to have what the statute refers to as an informational session if you are obtaining or comparing vendor proposals, provided that the vote on these proposals occurs at the next scheduled meeting. So what does that mean, practically speaking? If you've decided to shop for a new landscaper and you're getting 3 proposals from 3 different companies, you are allowed to meet as a board, not as an open session, and you can look at those 3 proposals, you can compare those 3 proposals, you could talk about these 3 potential landscapers, and then you would only need to make a final decision and take a vote on hiring one of those 3 at the next open meeting. But you can sort of do the analysis in a private board meeting. And that, I think, is helpful for obvious reasons. This bill also would allow notice from board members to the community to be as little as 5 days. This would be a meeting notice, could be as little as 5 days if at least 70% of the owners are full-time residents. This is a consideration that comes up in New Hampshire. I think we don't see it as much in Mass. Dean might agree or disagree, but
I do agree.
we're both in both states. This consideration about whether folks are residents of the association or not, I believe, comes up in New Hampshire a fair amount because New Hampshire tends to have a whole bunch of communities that aren't necessarily people's home, not their primary residence. You've got your ski communities that are used primarily in the winter, your lake communities that are used primarily in the summer. And in New Hampshire, it just seems that there's a higher chance that someone who owns a condo may not live there, and maybe nobody lives in the unit as their primary residence. Finally, this new provision does not apply to committees. This is relative to meeting notices. If the condominium documents do not permit committees to expend funds or sign contracts. And by the way, if your condominium documents don't say that, my recommendation is that as a board, you don't do that. You know, the board is elected to do the job of the board, and when it comes to spending money and or signing contracts, I think that should stay with the board. If you're creating committees within your community, which generally speaking, I think is a good idea. It's nice for the board to have help. And I think there are unit owners in a lot of communities who would like to participate in some way, but maybe don't feel like they can commit to being on the board. So committees in general, okay. But I think the board should always be careful about how they define the committee's role in the scope of their authority. And I would refrain from including expending funds or signing contracts there.
Totally agree with that. Really, the House Bill 1172 is sort of shocking in that it's a piece of legislation that really does give boards some flexibility. You know, when the board meets, you're supposed to give notice 10 days ahead of time to the ownership. You're supposed to produce an agenda. You're supposed to give or have copies of documents available that the board is looking at. All of that is onerous. So the legislature had this great idea to allow boards, at least for this one issue, to meet without having to comply with all of those procedural steps, have a meeting, discuss contracts. Then the next time you have a formal meeting, then you're voting. Therefore, the vote's going to end up in the minutes. So it's a nice law. It's very simple. It's not wide ranging, but it is helpful. And that's surprising because New Hampshire has been all replete with unhelpful legislation over the last 9 years.
Yeah, I think that what we're seeing, I'm hopeful that what we're seeing is some recognition by the New Hampshire legislature that several years of sort of hammering boards, has tied them up a bit too much. And I think folks are coming to the realization that, you can't make all of the people happy all of the time, as the saying goes, but that boards at condominiums really do need to be allowed to do the job that they've been elected to do. I'm hopeful that we will see a little more of this flexibility because, as you know, Dean, in recent years, they've really been tying the New Hampshire boards down.
No doubt about it. No doubt about it. We talk a lot about lien enforcement in these seminars, but the questions never stop, and it's an issue that is important to probably 90, I don't know, 95% of associations at some point or another, if not 100. It's just you have a budget, you need owners to pay. Therefore, what's more important than getting them to pay? So I'm here to talk about the Massachusetts lien enforcement process, what some might call the collection process, and then after that, Gary will talk about the process in New Hampshire. So in Massachusetts, we have 183A Section 6C, the super lien. What is the super lien? It is 6 months of budgeted condo fees plus the reasonable legal fees and costs incurred to enforce that lien. If you look at the last sentence there, it does not include special assessments. It does not include late charges, fines, penalties, or interest.
So, Dean, sorry, real quick. Two questions popped in about what I was just saying. It's actually two folks with the same question. They're wondering if proxies need to be notarized, and they do not need to be notarized, but they are required to have a control number. And excuse me, that control number is what associations are supposed to use to sort of vet and verify that proxy. The control numbers, it is specified by statute, should be assigned on a random basis, and the association should keep a master list of the control numbers and what unit that control number correlates to. And then using that system, you're able to verify whether or not it was a legitimate proxy, and to make sure that every unit submits no more than one proxy. You can cross that unit off the list when it comes in. So notarization, not necessary, but the control number is.
So there's a question, if it's in the bylaws, does it need to be amended? So if you could just clarify what you mean by that, if what is in the bylaws, we can get back to you. So just to step back for 1 second, in Massachusetts, there's an automatic lien for unpaid fees. If you haven't paid your June condo fee yet, in theory, the condo has a lien against the unit. It's not a lien that it's recorded, it sort of exists by law. But a lien, that lien for the June fee, for example, that goes in line behind any other lien that's already on record. But a priority lien jumps ahead. That's why it's called a priority lien. The priority lien is going to go ahead of the first mortgage. It's going to go ahead of a second mortgage. It's going to go ahead of judgment liens that have been recorded, by a credit card company or some other creditor. So you get your 6 months of condo fees plus the legal fees, and that is your priority lien. So how do you enforce the lien under the statute? The first step is to send the owner a notice of the arrears, and that has to be when the owner is 60 or more days in arrears. I think the process should start with the board or management company sending some sort of notice at 30 or 60 days just to say, hey, you're behind. Please catch up. Or if you don't, we're going to refer your account to counsel, and then you'll be responsible for their legal fees and costs. I like to start at the 3-month mark. So April, May, and June, fees have not been paid. Now is a great time to start the process with a letter to the owner. 30 days later, I'm going to send, there's 2 required notices to the first mortgage company. One is that the owner is 60 days or more in arrears. We call that the 60-day notice for obvious reasons. And the other is the 30-day notice, which says we are going to file a lawsuit to enforce the lien in 30 days if it's not resolved. So typically, I will send both of those notices simultaneously in month 4. So in this example, April, May, June, and July now owed, where it's 30 days later, we're in July, 4 months are owed. I'm going to send both of those letters to the mortgagees. Sometimes I'll send just one notice, the 60-day notice in month 4, 30-day notice in month 5, kind of depends on the situation. And then the final step in the process is to file suit and then record a copy of that complaint with the Registry of Deeds. So unlike the lien for my June fee, which I forgot to pay, the priority lien is actually recorded. If you go to the Registry of Deeds online or in person, you are going to see this physically recorded against the unit.
Dean, you have a question that popped in about payments. And they're asking whether or not the inclusion of a monthly condo fee coupon, which some associations use, will in and of itself designate that that payment is going towards that fee, meaning that the association is no longer free to apply that payment as they see fit.
Interesting. Yeah, that's a tough one. That's really on the borderline. You know, usually we tell clients we want them to apply payments to the oldest outstanding debt because, let's say 9 months are owed because they have no legal counsel or terrible legal counsel, and no one told them about the priority lien. So I can only get a lien for 6 of those 9 months. So if you get a payment, apply it to month 9, not month 1. So if you're sending in the payment with a coupon for June 2025, there's an argument that the owner is directing the board how to apply it. And if the owner directs, the board has to follow that. But I think it's arguable. I mean, it's sort of like, you're just sort of appending a coupon to it. Is that really direction? It's arguable.
I tend to be risk averse. I would say I would probably advise a client to look at that coupon as an instruction regarding that payment, if only because if we fast forward, I would find it to be a tough moment if we were in court with this delinquent unit owner and, a judge said, well, if you didn't think sending in the check with the June coupon was telling you that that payment was for June, what did you think it was telling you? I would imagine that would be a tough moment. And so for that reason, I would tip the scale that way. But again, I tend to be risk averse. And like we always say, cases are often fact specific. You might run a case a little bit differently if someone is delinquent for the 8th time. Some associations have these chronic delinquent owners that, just really sort of need to be handled fairly aggressively because for whatever reason, they just don't accept the fact that they're supposed to be paying.
There's a follow-up question. What if the coupon itself says the payment will be applied to the oldest balance? Well, I think then there's a great argument that it should be applied that way. Or perhaps the board has a written policy that regardless of what coupon you submit, that it will be applied to the oldest outstanding. All of those would be new facts that, weigh in favor of applying to the oldest. I mean, I think Gary's probably right. I wouldn't want to be before a judge and try to argue that the payment with the June coupon is for something else, but I like to try to see things in the way most favorable to our board clients.
I think it's great if there's language on the coupon that says how the payment's going to be applied. I think that would change things for sure.
And a comment from a property manager that says many companies just send the checks to the bank and never even look at the coupons or anything that's accompanying the check, and that is absolutely true. And it certainly muddies the waters in terms of how to apply. So I guess the answer is really establish a policy and stick to it unless someone sends a letter that says you must apply this to the June 2025 fee. Absent that, apply to oldest. So I just want to kind of look at things from a practical perspective. You see in front of yourself a ledger for John Q. owner. You see a balance forward of $1,000. So that's from 2023 in this example. Just imagine yourself in October 2024 for a moment. You see a special assessment. You see some late fees and regular monthly fees. So with this, what is the priority lien? It's 6 months of fees. That's May through October. It's the legal fees, which you'll see at the bottom of the ledger there. That was typed on by the law firm when they sent out a letter. And why is that the priority lien? It's what the statute provides for. It provides for a 6-month window beginning from when you record the lien going back in time. And special assessments, fines, and late fees are all expressly, meaning all with the text of the statute, are excluded. So, this particular condo waited too long to start the process. They've had, by the time this started, something like 9 or 10 months owed, and they started the process too late. They also assessed a special assessment when they should have amended their budget and done a supplemental fee. Late fees, there's nothing you can do about that. Maybe you'll recoup them in time, but you can't make a lender pay them as part of the priority lien. There was this famous case, Drummer Boy Holmes versus Britain. Our firm was involved in the litigation for over a decade. This owner hadn't paid condo fees for years, well over a decade when it was all said and done. And he tried to say that a condo could only have a single priority lien at a time. And thankfully, our firm prevailed. And the law of the land is that a condo can have multiple priority liens at one time, as long as you follow the process I just talked about over and over again. So maybe you file a suit in January, you've got January, or excuse me, you file a suit in June, so you have January to June covered as your 6-month priority. Then come October or November, you're going to start restarting the process by sending new statutory notices to the owner and to the lender. And then in December, you file a new lien to cover from July to December. So now you have 12 months covered, all prioritized, which means eventually the first mortgage holder is going to pay you off if the owner does not. And I should have talked about that from the outset. Why do we even care about a priority lien? And it's because if the owner's behind and can't pay you, it's going to be really tough for that owner to catch up. And oftentimes, what saves the day is the lender stepping in and saying, well, we want to be the first lien holder. We don't want to be in second place. So we're going to pay off the $2,000 that's owed and tack it on to the loan balance. So instead of the mortgage being for $200,000, now it's $202,000. And now the mortgage company is back to the first lien holder, and that's all they care about. Because the payment of fees is a violation of the mortgage as well. So they have many, many reasons to want to pay.
Dean, you have a question that popped up that I'm sure you will make short work of. The question is, can a homeowner hold back fees because they are not satisfied with how the trustees are handling issues, such as lack of meetings or failing to abide by rules and regulations?
A great question, and the answer is unequivocally no, they cannot. And that is the law of the land in Massachusetts, and it's been that way for a long time. There's very, very clear case law that it says explicitly you can't. It's just like paying your property taxes. You might think your mayor or your town council is a bunch of fools, but nevertheless, you have to pay your property taxes. Likewise, you have to pay your condo fees. If you think the board is stealing money, if you think the board are misspending money, if you think the board's doing nothing, it doesn't matter. You have to pay and then take up your issues separately. Even if you feel an assessment is inappropriate for some reason. Sometimes there's massive projects, roof replacement, siding replacement, and there's a second supplemental fee in addition to the condo fee. And a lot of owners say, you can't spend $500,000 replacing roofs. This is ridiculous. I'm not paying that. Well, first of all, yes, the board can do that. And secondly, you have to pay it. You can't, if you believe the board has overstepped its bounds, the recipe created by case law is to pay it under protest, one, and then two, take up your grievances with a separate legal action. So hopefully I answered that. I couldn't be more passionate about anything than that issue. So, and Gary knew that.
Yep, and there are two more. The next two questions, I think, relate to each other. I'm going to present them together. The question is it correct that fees are still owed but wouldn't be collected in the event of a foreclosure? And then what I think is a related question, what happens if a unit is in foreclosure and the lender doesn't pay?
If a mortgage company is foreclosing on the unit, by all means, all is not lost. What we would do is make sure we record a priority lien prior to that foreclosure sale. So even if the owner and lender didn't pay for whatever reason, they have to pay after the foreclosure sale. So if I record my priority lien today, bank forecloses tomorrow. If the bank owns it after the sale, or if a third party buys it after the sale, that third party is obligated to pay the priority lien, because if you have four liens on the property, you get your priority lien, your mortgage, and other liens. When the second lien forecloses, the priority lien's still there. It does not get wiped out like the junior liens. Junior liens get wiped out. So as long as you are in touch with your attorney, making them aware of a pending foreclosure sale, we can absolutely make sure you get paid. Now, I can only get you the 6 months. I can't get you 10. I can only go back in time 6 months. So make sure you're getting these issues to your attorneys, in month 2 or 3, so we can stay on top of it. And then if the lender forecloses tomorrow, whoever buys it at the sale will be responsible for July and August, September, and so forth. Getting back to the slides. And look at that. We were going to talk about it anyway. So the impact of a lender foreclosure sale. So who owns the unit? It depends who's the high bidder at the sale. Oftentimes it's the lender, because they're buying it at their own sale, but it can just as easily be a third party. So if lenders are back in 2011, there were 1 million foreclosure sales without priority liens being paid first. At this point in time, lenders are really good at responding to our notices. We know who to contact. We have our contacts at almost every bank, and we're getting clients paid prior to sale, generally speaking. But if you don't, rest assured, you are going to get paid. And really, it's the 6D certificate that the lender or the buyer, whoever that third part, whoever owns the unit, is going to need a 6D certificate to sell to someone else. And that's when you're going to get paid that priority lien. So as of the date of the sale, whoever was the high bidder is sort of the owner, but the sale hasn't closed yet. So it's a bit of a gray area. But as of the date of the sale, the buyer is going to be responsible for payment of fees and maintenance. But practically speaking, until the sale closes, that third party or the lender is not going to be in there maintaining the unit. They're going to wait till they're of record and maybe evict the former owner who continues to reside. Just looking at some questions. Worst case scenario is when an occupier is not the owner, the mortgage is paid, and the real estate tax isn't. Yeah, I know exactly what you're talking about with this question, Patricia. And the question she refers to is, we have a dead owner, and the unit is being occupied by the dead owner's children, but they never probated the estate. So it's and there's no lender to step in and pay. So you have a situation where the owner is really the estate of the dead person. So it's a complicated process, but you still can get paid. Almost in Massachusetts, in almost any circumstance, you can get repaid as long as you're engaging counsel and not waiting too long. If 18 months are owed, I am not going to get you a check for 18 months. But if 6 months or less are owed, I am almost certainly going to give you a check. What happens if there are decades of unpaid assessments and insider mortgages, never requested certificates? Should the association file a certificate showing tally owed? So two things. Let's just say, 100 months are owed. If the owner sells it to a third party, you can get 100 months paid, no problem. We're really talking about a circumstance where there's no equity, or they're in a foreclosure scenario where you're relying on the priority lien to get paid. So let's say the mortgage is for $500,000, but the unit's only worth $300,000. If the owner were to sell the property, it's going to be a short sale, and no one's going to get paid except the first mortgage holder. And even they're going to take a haircut. So you need that priority lien to jump in line and get paid first. That's the power of one, the priority lien, and two, the ability to foreclose on the lien because you're forcing the lender to deal with it. But there could be 10 years worth of unpaid monthly fees, but the unit is worth $1 million and there's no mortgage. So when this owner wakes up out of God knows where they've been and sells it, they have no choice but to pay 100% of what is owed. And if they don't get a 6D certificate, the buyer is going to inherit 100 months of unpaid fees, and they're going to have to pay it. And if they don't, we can sue them and foreclose on them. All is not lost unless there is no equity or the lender forecloses, and then you're relying on the priority lien. When a homeowner passes, can the estate hold back condo fees until the estate is settled? I mean, technically not. Technically, the estate should be paying, but practically, there's often no ability to do so. Maybe the heirs don't have money. Maybe they're waiting to access the dead former owner's money. So I think you can be patient, let it play out in probate court, let them sell the unit. If there's equity, I wouldn't be too worried about it, but it's something you want to talk to an attorney about to make sure you're not being too lax. Apart from racking up successive liens, can the association foreclose on a long delinquent owner? Absolutely. So once you file suit and get your priority lien, it's going to be a court case like any other, where you're going to go to court at some point and have a hearing and figure out what your damages are. So you're going to prove to the court with account statements what is owed, and ask a judge to approve it. And not only that, approve what we call an order of sale. So if you have a lender that doesn't pay, or there's no lender and it's just the owner who owns it free and clear, that is the power of the Massachusetts condo statute, is the ability to foreclose on the lien. So no matter what let's say there's no mortgage, owner, who knows, has gone overseas or just doesn't care anymore and gave up, and who knows. The mechanism to get paid in that instance can only be a foreclosure sale by the condo. And it's quite easy to do if you know what you're doing, which we do, of course. So we're going to go to court, get a judgment, and then about 45 days later, we're going to hold a public auction, sell it to the highest bidder. Then 30 days after that, we're going to close that sale and cut you a very large check. In Massachusetts, it's hard not to get paid if you have a law firm that represents condos on your side. There's a whole host of ways we can get you paid. Can you clarify the specific difference between a priority lien and regular lien in New Hampshire? Well, with that question, I will hand it over to Gary, and he'll tell you just about that.
Okay, yeah, I was going to say that last one, I would like to think I'm going to be covering, but certainly if there's a continuing or a follow-up question on that, folks should feel free. So we are now going to talk about lien enforcement in New Hampshire. Next slide, please. So as far as New Hampshire collections, I'm going to sort of take a step back, prior to delinquency, because I think it's important to understand in New Hampshire, there's a difference that gets back to the board's ability to levy the assessments in the first place. The adoption of the association's budget happens in New Hampshire according to section 40C of 356B, that's the New Hampshire Condominium Act. And although the board adopts a proposed budget, as the process goes, there then needs to be a meeting. And although it's unlikely that this would happen, 2/3 of all of the owners, not who's at the meeting, but 2/3 at all of the owners, if they come out to the meeting and reject the budget, then the budget can be rejected and it doesn't go through. And so, in New Hampshire, there starts to be some question in the process prior to the delinquency, prior to the assessments, because it's the community's ability to engage in the process of deciding what is going to be assessed to them in the first place. Boards have, in this respect, a little bit tougher job in New Hampshire. So I did just want to mention that. We can go to the next slide. More reasons to avoid special assessments, as Dean mentioned. This is the case in Mass too. They are explicitly excluded from the priority lien. That is also the case in New Hampshire, so they're going to be harder to collect. But again, an important difference between New Hampshire and Mass. In New Hampshire, special assessments have to go through the same process as the budget. And so again, the board is in this precarious position where there needs to be a meeting. And if enough of the community shows up at that meeting and says, we're not having this special assessment, then that assessment doesn't go through. That, of course, can be highly problematic for New Hampshire boards, because the special assessment, I'm sure the board's not doing it for fun. And if there was enough, of an unexpected tragedy that has befallen the association, and there are important things that need to be done, and the money needs to be raised to take care of that, the association could just really end up in a bind if the unit owners also come out to refuse to pay for things. So I think this part of the New Hampshire condominium statute is not great, because it creates the potential for these problems. But again, it is important for boards and property managers to know about it, because this is why you really need to make sure in New Hampshire, possibly more so even than Mass, that you're not going to ever be relying on a special assessment to work up the capital that you need. Next slide. So this is a sample case timeline in New Hampshire. On the left, I'm noting the age of an imaginary delinquency. And I like between 45 and 60 days, for an association to start taking action in New Hampshire. Part of that is because the New Hampshire priority lien language in the statute, or super lien language in the statute, is a bit different. Technically in New Hampshire, that language requires the mortgage holder to receive a notice about the delinquency between the 60th and 70th day of that delinquency. And so in New Hampshire, I typically advise clients, at around 45 days delinquency, if you would like to send them a letter yourself, that's a good time to do it. That's a good time to say to a unit owner, hey, May isn't paid, June isn't paid, we're halfway through the month, please be sure to get your account caught up. Otherwise, next month, when you hit 60 days, this is going to be sent to the association's legal counsel. Oftentimes, we start with what is now could be loosely referred to as a 42-day demand letter. The days that we allot here are the result of a combination of state law and federal law, and our firm's desire to help both us and our clients avoid any issues with the debt collection law, which is very restrictive, unfortunately. And so in this initial period, when we make contact with a unit owner, they have a decent chunk of time to respond. Following that, however, there is a title exam and a notice of default that issues. That's a statutory notice. As Dean mentioned, the process in Mass, very similar to what we do in New Hampshire. There's a 30-day notice to the mortgage holder and a 60-day notice to the mortgage holder, and both of those go at the same time so that the case can keep moving. I noted in red there that part of this process is to also create and record a quote-unquote paper lien. That is another important difference between New Hampshire and Massachusetts. As Dean mentioned, in Massachusetts, associations have the benefit of an automatic statutory lien. And by law, when a unit owner fails to pay an assessment, the association has a lien in that amount as of the time the assessment was due. In New Hampshire, the association needs to create a paper lien. A document that says that there is a lien on the unit. You identify the association, you identify the unit and the unit owner involved, and you lay out the various items that they owe, which can include the legal fees But all of that needs to be on there. And the lien needs to be signed and then recorded at the Registry of Deeds. This question comes up often, and by often, I mean almost daily in my practice. Who is signing this lien? Unfortunately, what the statute says is the president or another officer of the association. Unfortunately, that language would exclude anybody that isn't an officer of the association. And so a lot of times, folks want their property manager to take care of this, or someone else that might be involved with the association's accounting. Technically, that becomes a tough issue based on the language of the statute. And although it's not convenient, it is probably best for board members in New Hampshire to be somewhat available to be able to execute these paper liens when they need to be. Now, as far as the process goes, again, similar to Massachusetts, the unit owner has gotten their notices, a paper lien has been recorded, the mortgage holder has gotten their notices, the time period to respond to those has run, and what happens is a complaint gets filed in the court. And another reason why it's good to start the legal process at about the 60-day mark in New Hampshire is that as these notices go and as the response windows tick away, and you may or may not get responses, and depending on what those responses are, they might take a little time. But in any event, you're going to reach again, 5 to 6 months by the time you get to court. And, ideally, that's where we like to keep it in these cases, because that is the maximum that's allowed within the priority lien in New Hampshire as well, same as Massachusetts. Once the complaint is filed, there might be some other mechanisms in New Hampshire that we can look at, such as attachment of rents or even termination of services. That can vary by association. So that's going to be a case by case as to whether any of those things are applicable. It also varies by association whether or not that could be effective. In other words, if someone is not renting their unit, then intercepting the rent is not going to be a big concern for them. And if the association doesn't have amenities, such as, for instance, a clubhouse or a pool that someone might be interested or motivated to make use of, if the association does not have those items, then termination of services may not do so much to get their attention. But if the association has a pool, if it's summertime, then, locking somebody out of the pool and terminating those privileges, a lot of times will absolutely get their attention. So again, it's a tool that can be used when the circumstances are right. And we can go to the next slide. So the super lien. As we can see, there's a comparison here of the statutory language in Mass and New Hampshire. The super lien is defined the same way. In other words, it's a maximum of 6 months of the condo fees. It does also include the legal fees. That's true for both. Special assessments, late fees and fines and things like Dean was talking about earlier, in the same way that those are restricted from the super lien in Mass, so too is the case in New Hampshire. Another restriction in New Hampshire is that the state did not have its super lien law as early as Massachusetts did. And so you really, as an association, only have this super or priority lien against a mortgage if the mortgage is dated January 1, 2011, or some more recent date. And so older mortgages, and there are plenty, that are still out there, older mortgages are not subject to New Hampshire's super lien statute. Next slide, please. All right. This was another statement about what is not included in the super lien. And again, that's the same for both states. And again, I'll just repeat, this is why it's so important. Like Dean said, late charges and things of that nature, that's one thing. But you don't want to have special assessments hanging out there not getting paid. And so it is really best to avoid those. Rolling the lien, and apologies, the lien, L-E-A-N, is a typo, might have been an auto correct. We're talking about a property lien, which is L-I-E-N, like at the top of the slide. As Dean mentioned, rolling the lien happens in mass. It all flows out of that case with Britain, the drummer boy case. In New Hampshire, no such case. And unfortunately, even more restrictive, the statute actually prohibits the rolling of the lien. And so in New Hampshire, the Condominium Act 356B actually includes language that is explicit about the fact that an association can only have one priority lien outstanding and unpaid at any given time. And so again, things become a little harder for folks in New Hampshire, a little more stress for the boards and the property managers, but you've got to keep these cases, you've got to start them on time, and you've got to keep at them, and you've got to make something happen in these cases, because if someone becomes a long-term delinquent, we don't even have the option of rolling the lien. We can continue to chase someone for what's owed, but we don't even have the option of rolling the lien to create a second priority lien. So this is now a continuation of the case timeline. Unfortunately, these cases do take time. And my point in showing everybody the timeline was not that any of you would memorize it or that you need to, but it is just to show you that there are a lot of steps to the process, which is why, you know, time does pass between when these cases open and when they close. And we really just have to kind of chip away at it. But after the complaint is filed, which we talked about on the last timeline slide, service of process has to be achieved. That is typically done by the sheriff's office. Once the defendant is served, they have a time period, which is 30 days, to answer the complaint. If they fail to do so, then we can file for a default. Eventually, the court will schedule a hearing on damages. Typically, they provide a 14-day notice for that. After the hearing, as Dean mentioned, you know, you go to the hearing, you convince the court as to what your damages are, how much is really owed by this unit to the association for whatever the various reasons are, whatever it tallies up to. In New Hampshire, as in Mass, we do have the ability to ask the court to also award the association their legal fees and costs. All of that gets put in front of the judge, and eventually a judgment issues. Usually is pretty close in time to the hearing. We usually see within 1 to 2 weeks a judgment roll in. We do tend to try to help things along by making the judge's job easier, and we typically provide them, you know, with all kinds of documentation, affidavits to prove the damages, as well as very specific explanations of the amounts that we're looking for. And then after judgment issues, a unit owner does have a period of 30 days during which time they can pay on that judgment. We don't see it happen often, unfortunately, but there is a period there where a unit owner could either accept defeat if they were disputing the charges for whatever reason. They could finally accept defeat and make that payment, or if it were a unit owner that really didn't have the financial resources, they have one last chance here in the 30-day period to, I don't know, tap a retirement account or ask a relative for a loan, or whatever they might do to get themselves out of this situation. But that payment period is there just in case, you know, they can make good on the judgment. And we can go to the next slide. If they don't make good on the judgment, then the process needs to continue. We make a request for an execution. That is us letting the court know that the judgment wasn't paid and that we want this further document. The court issues the execution, and once we have that, we provide it to the sheriff. In New Hampshire, unfortunately, we have not, despite several attempts, and I'm sure we will continue with our attempts in this respect. but we have not been able to get the legislature to put into the statute a foreclosure remedy in the same way that Massachusetts has. Dean mentioned in Mass that, when you get to this point in the case, what you're really conducting is a foreclosure sale, and the association conducts that sale in the same way that a mortgage holder would if the mortgage was not being paid. In New Hampshire, more often than not, there is some exceptions out there where maybe the condominium documents happen to specifically contain language authorizing a foreclosure, but short of that, in New Hampshire, by and large, you're looking at a sheriff's sale. And so we provide the execution to the sheriff, and the sheriff then undertakes a process of dealing with advertisements that are required by law, and so on. They also coordinate with our office as far as scheduling the actual sale. That does get conducted by the sheriff. In Massachusetts, it's an auctioneer if it's a foreclosure. In New Hampshire, it's going to be the sheriff for the sheriff's sale. And we can go to the next slide. After a sale, there is another period of time where the buyer can close on that transaction. That's typically 30 days. That is not usually enough time for someone to get a mortgage, but typically the folks that are buying these properties at a sheriff's sale are not getting a mortgage. These are investors who have some money. They're spending it on the property. They're buying it in this scenario that does carry a little bit more risk. But for a lot of folks, this is either, what they do for a living, the so-called flippers. It can be their primary job, or it can be something that they do on the side for income. But these folks usually can close fairly quickly because they are not typically trying to finance these purchases. Then closing happens. And then there's a final accounting made, and a final payment will issue to the association. So effects of a sheriff's sale, distribution of the proceeds. This is consistent with what we've been speaking of, but if the condominium has a priority lien that's involved, they will get that priority lien paid first and foremost. The next priority becomes the first mortgage, whatever balance there might be on that. And then in third place is the association again for non-super lien debt. And so if your super lien didn't make you whole, you might still get a chance to get some more funds if the property sold for a high enough price to pay the mortgage, and we still are holding on to some money. If we're holding on to some money, then afterwards, we can get into things like a second mortgage or other liens that might be out there on record. For notes here, we've discussed this, but again, by way of reminder, unfortunately, there is no super lien in New Hampshire if the mortgage is before January 1, 2011. The sheriff's sale is not going to extinguish a mortgage if it's not on a priority lien. And the third and possibly most important difference between the sheriff's sale and a traditional foreclosure is that the unit owner who's losing the unit, they have a 1-year right of redemption under the statutory law in New Hampshire to pay what they owed and still retain the ownership of the unit. The law does allow a new owner, so if you bought it at a sheriff's sale, you don't have to do nothing for a whole year. You do have the right to make use of the unit. You do have the right to evict someone if they're in there. You can put in your own tenant and charge someone to be there. You're also allowed to make necessary repairs. And if you do make necessary repairs, you are allowed to add that to the amount that must be paid to you if someone is exercising their right of redemption and holding on to that property. Still, nonetheless, I find that 1-year right of redemption has a chilling effect in New Hampshire because there's a lot more uncertainty involved, a lot more risk that someone has to accept if they're buying a unit at a sheriff's sale in New Hampshire, and then knowing that they have to wait for 365 days to go by so that they can truly and safely know that they are the owner of this unit and that they're not going to be losing it by redemption.
Gary, one question for you. What about the legal costs after judgment? Can they be recovered from the proceeds?
I am of the opinion that they can. I think that post-judgment expenses of the association that are incurred in the collection, there are different issues, like if people are breaking rules and so on, and I think that would be different. But if the association's incurring legal expenses in the further pursuit of the collection of the monies owed, I am of a firm belief that those should be treated the same as the pre-judgment expenses, because I think it's clear that the intention of the law is for associations to be able to get that money as part of their recovery. Practically speaking, I think it's rather essential that be the case, because let's face it, if associations were gonna incur $5,000 in legal expenses so that they could get the $5,000 that somebody owes them, then their net is zero, and there's really no point. So I think that's a good question, because I don't think it's laid out as clearly as it needs to be in the law. And some folks would maybe debate this, but at the end of the day, I would feel comfortable. I'll get back to I imagine myself in front of the judge analysis. Here, I would feel comfortable saying to the judge, look, if the association doesn't get their legal fees, their net benefit is zero, and your whole process offers no value. And that's contrary to everything else that's in the law. So I think there's a great argument that associations should be able to recover that money.
I certainly agree, Gary. Well, I see no other questions, so I guess with that, we will bid farewell to the 65 of you who have hung on. We greatly appreciate you joining us. And stay tuned, because we'll continue to have these. I think we're going to take a little bit of a respite for July and August, but we will be back in September with the continuing series of webinars. Gary, anything else?
That is all. Just again, thanks for the folks who tuned in today. Like you say, especially those who hung out. Thanks, Dean, for teaming up with this. It's nice to be able to work with folks doing these.
Agreed.
I will also note that a question just came in. It's about getting copies of the slides, and yes, those will go out to attendees. If not today, in the very near future. It will likely be an email from Julie Sarasulo of our office. So if you don't see that in the near future, be sure to check, your spam folder or something along those lines. But if you registered as an attendee today, yes, you will get sent a copy.
All right, everybody. Thank you very much, Gary. Thank you. I'll talk to you later.
All right. Have a good one, everybody.